Hello friends, welcome. I'm quite sure that everybody who is following the telecom sector might have seen this news, wherein the operators have filed a curative petition against the Supreme Court verdict on AGR in 2021, where the Apex Court had dismissed the telecom companies seeking correction of errors in the calculation of AGR dues payable by them as per the top court judgment in 2019. So, if this curative petition is accepted, then it will be a very significant outcome for the telecom industry, where because Bharti as well as Vodafone Idea might be able to get a significant relief from the point of view of their dues that they are liable to pay to the government, which is a very large amount. Now, what I thought is that it will be useful if I take you through this complete judgment starting from the beginning until the end. Now, since this is a very long 20 years duration legal tussle between the government and the operators, so I thought of breaking it into three parts. The first part I'm going to basically cover today, and then following I'm going to do two more parts. The second part will be the mistakes which both parties committed, the government of India as well as the operators, and the third part will be the analysis of the judgment, and especially the portion which excluded the PSUs. So let's start evaluating the initial portion of this series, which is the Supreme Court judgment and what transpired between 1999 till when the judgment came out in 2019. So what happened initially? So I will lay out the facts. The fact one was 22nd July 1999, when the migration package was proposed by the government and it was accepted by the operators unconditionally. So if you see here, unconditionally. And in this migration package, I've extracted one paragraph out for your for your perusal, which said that the total revenue of the license fee company will be considered as a base for charging the license fee. So it's very important to know that total revenue was mentioned here. However, it also said that the definition of revenue, that is the total revenue, will be decided later after receipt of the TRAI's recommendation, and the government decision will be final. So what it said, that though it used the word total revenue, but the definition of the total revenue it was supposed to decide later after reviewing the whole matter with TRAI, and then based on the inputs that the government receives from the industry, the decision was supposed to be taken. Now, what is fact 2? The fact 2 was that TRAI did provide a definition of AGR which included two buckets. One bucket was components which will be included in the AGR, and there was a deduction bucket. And they may very clearly mention that the gross revenue from cellular mobile services will be under the operation under the license, though it did not clearly define telecom versus non-telecom. It did not bifurcate the AGR based on telecom versus non-telecom. However, it clearly said that the cellular mobile services operational will be under the license. However, DOT rejected the TRAI's recommendation without giving any reason. Now there are certain other facts. Let's go through them. So the fact 3 was that while the TRAI was carrying out their analysis based on the inputs that it received from the industry, DOT was carrying out another independent analysis for understanding the definition of revenue by hiring a consultant on 6th October 1999. However, DOT did not place the report of the consultant before the TRAI while seeking its recommendation. So it's kind of a non-transparent activity which was going on in the background. The operator's initial grievance was before the OSPI case. OSPI case is what? 11 November 2011, we'll talk about it. Was centered around the DOT's claim of license fee from non-telecom revenue, which does not require a license from the DOT. So what the operators were saying, the DOT is seeking to collect license fee from the bucket which was non-telecom in nature, for example, interest payment, property rent, there are many such items. So these do not require a license. So the operators were telling the operators' main argument was before the Supreme Court that this does not require a license. Therefore, it is unfair for DOT to seek a license fee on non-telecom portion of the revenue. Before the OSPI case, all TRAI recommendation, the TDSAT judgment were principally anchored around the assumption that DOT has no right of seeking license fee from non-telecom revenues. Very, very important. Now, what happened was that when the Supreme Court judgment came out on 11th November 2011, which is considered as an OSPI case, which is called out as an OSPI case, it established DOT's right to collect license fee from non-telecom revenue. And it also said that the TDSAT really does not have the jurisdiction to decide what the powers of DOT are. Because once the DOT is the licensor, if DOT and the operators together decides on a terms of contract, then the TDSAT can only interpret the contract rather than basically decide what the terms of contract would be. That's the main premise of this OSPI's judgment was. That is the 11th November 2011 Supreme Court judgment was, which is called out as OSPI judgment. That DOT does not have, TDSAT does not have the right to decide the contract itself. It can only decide to interpret. It can only interpret the contract. So, but in that judgment, Supreme Court did not go into specifics of the DOT demand and empowered the TDSAT to look into the legality of the demand within the purview of the license agreement, which basically has the TOT has the right to decide, not the TDSAT. Now, coming back to the reason for dispute. Now, the reason for this dispute, as I already pointed out, that DOT had initially set up an expectations for the operators that the definition of the revenue or AGR would be established post consultation with TRAI during the migration package agreement. Means after the migration package was signed unconditionally, then they will carry out a transparent consultation, and on that basis they will decide what the definition of revenue would be. But instead of doing that, what they did, they just decided unilaterally. They did not consider what the inputs that the TRAI gave to DOT, and they also did not submit the consultation report before the TRAI while they were taking this decision. So operators' assumptions was that they would basically be heard and it will be all transparent, the revenue, and since it was an opaque process which did not meet the expectation of the operators, therefore is the genesis of the dispute. Now what the TDSAT order and what was the subsequent development? Now TDSAT was under the impression that it has the jurisdiction, so it was basically trying to decide what the terms of contract would be. And in 2011, when the Supreme Court came out with the judgment, it demolished the TDSAT rights to decide what the terms would be of the contract between the licensor and the licensee. It said that TDSAT is a body which will only interpret the contract rather than decide what the contract would be. Just like the Parliament basically makes the law and Supreme Court interprets the law, almost in similar, you can basically make a similar analogy, right? Now, there is one more point here, the legal and the moral stand. So it is clear that DOT actually had full legal right to decide the terms of the contract and reject the operator's claim that the license fee will not be charged on non-telecom portion of the revenue. But from a moral perspective, as a licensee, as a government, I have the responsibility to undertake a fully transparent process and explain my stance very clearly to the party who is getting impacted, that why I am taking that stance. So DOT did not do that. Neither it basically submitted the consultant report before the TRAI during the consultation process, and therefore the operators are always of the view that DOT is taking an unreasonable stance, and that's where the problem basically happened, and it became a perception issue from the point of view of the operator that they are not being heard, and their legal and legitimate rights are getting violated in an untransparent and a unilateral manner by DOT. Now, what was DOT's rationale, and what were the subsequent arguments? The DOT's rationale was that if they exclude the non-telecom portion of the revenue, then it will become a means for evading license fee. Means that is basically lead to arbitrage. The operators will do innovative accounting, and they will figure out a mechanism to evade license fee. And therefore, that is the reason why the total revenue of the operators were included. And in the judgment, Supreme Court also said, the recent judgment, though I am basically putting the cart before the horse, but it is important for you to know that the Supreme Court also said that if the operators were so concerned about the inclusion of the non-telecom portion of the revenue with the telecom portion, they could have excluded their non-telecom business in a separate company. Why didn't they do that? So that is where the problem was, the DOT's rationale was. Now, the second problem was that DOT was confused. DOT really didn't know that what items from the so-called non-telecom revenue should be included and excluded. And this is clearly evident from the TDSAT judgment of 30th August 2007, where many of the items DOT really did not provide any reason. For example, DOT objected to excluding capital gain from AGR without providing any reasoning. Then on the foreign exchange fluctuation, no clarification from DOT on losses due to the exchange rate fluctuation could be deducted from AGR. So DOT did not clarify as to what the mechanism would be to treat with foreign exchange fluctuation. Similarly, vendor credit also DOT did not provide a counter argument. Income from property rent, DOT accepted that they should have been included. There are other income, including miscellaneous incomes, where DOT concurred with TRAI's recommendation that these should be included from the AGR. So there are many items DOT actually concurred from a portion of from the bucket of the non-telecom. So DOT, you can see here that it all started in 1999 till 2007. DOT was itself confused what should be the line items on non-telecom revenue that it should be including and excluding. So even after 7-8 years, DOT was confused. So you can imagine that you are having a contract signed with the operators for them to execute telecom services, but both the licensor and the operators are themselves not clear what the terms of contract is, which looks somehow very unfortunate. Now coming to the TDSAT observation of the definition of revenue, because what happened was when the TDSAT came out with this judgment, which was demolished by the Supreme Court on 11th August 2011, TDSAT also got frustrated. TDSAT said that in hindsight, the licensee might have inadvertently prompted Supreme Court's broader interpretation of the revenue clause by elevating the dispute to almost an abstract level. It's a very important point which TDSAT saying that why did you make a fuss out of it? You could have basically settled with the government rather than basically taking a hard stand. So he pointed out and he said that because you extended this battle to an extreme position and did not want to compromise, it led to a situation like that, you had to deal with the judgment of 11th August 2011, where the jurisdiction of TDSAT was considered as invalid by the Supreme Court, right? And then it says that TDSAT pointed out that Supreme Court order of 11th August 2011 suggesting that DOT's initially had been more reasonable stand on the definition of revenue. Now note this, DOT was more reasonable before 2011 when the Supreme Court came out with the judgment, which is also very strange that what happened in 2019 was a very hard stand which the DOT had to take, but it was more reasonable. So what I am basically trying to say is that the matter could have been decided much more amicably initially if it did not have dragged on for such a long period of time. And therefore, the outcome of the litigation is that the first round of litigation, the operator lost the case in the Supreme Court without TDSAT implies that it could have been due to the way the issue was argued. So TDSAT is very clear that it's basically a little bit of a issue which is not properly handled from a legal perspective by the operator. That's why they came to a conclusion like this. Now let's preview the judgment of Supreme Court of 24th October 2019. Now what was the judgment stands on operator? So basically what Supreme Court said is that they made the judgment more stringent and broadened the definition of revenue more stringent than what the DOT had initially envisaged. It's very important. What was the expansion of this rationale? The basis was that it was a deterrent of accounting manipulation, which was initially basically suggested by the consultant, that the operator will deal with accounting manipulation. But the point here is that if that was such a big issue, then why the recently DOT as a part of the telecom package excluded the non-telecom portion of the revenue from the AGR definition? If that was the issue, that also the question should be raised, right? So though I understand the concern, but this concern is not relevant under the current scheme of things where DOT has taken a stand which is completely opposite to the stand that it continued to take for last 20 years till the judgment happened in 2019. And then Supreme Court made a very important point here. Supreme Court noted that any concession made out by DOT regarding non-refundable deposit were palpably incorrect. Means Supreme Court is saying that whatever concession DOT gave to the operators in the bucket, from the bucket of non-telecom revenue, was palpably incorrect. Means Supreme Court basically went much harsher than what the stand DOT had taken earlier. Now, what was the reason for the outcome? The reason for the outcome was that dispute got extended for a longer duration of time. It should not have been let. Operators, neither the DOT nor the operator should have let the dispute got extended to such a long period of time, which led to such a very bad outcome. Then there was an ineffective early intervention. The initial debate between TRAI and TDSAT were totally futile, though these entities basically lacked power to provide relief. High Court involvement also came later, but was not decisive enough. It basically exposes not only the regulatory system of our country, but also the legal system's vulnerability. That the case highlights the weakness of our legal system also. Because in one hand, you have been fighting a case for such a long period of time, and Supreme Court intervened in 2007. If there was a jurisdiction issue, then 2007 itself Supreme Court have highlighted the jurisdiction issue and prevented the case being dragged from 2007 till 2011, right? It could have saved some time, 4 to 5 years, but it did not do that. And there were many missed opportunity from the operator point of view that they could have argued an AGR free regime, right? And that would have also prevented the 2G scam. Because if, let's say, the migration package was taken in 1999, but the operators could have said that we don't require to have this license regime of revenue share to continue forever. We would like to acquire spectrum through auction. Since we are going to acquire spectrum through auction, this license fee based on revenue share, now it should become redundant. Nobody made a statement like that before even the 2G scam. So that is why this whole issue became so bad and the outcome becomes such harsh for the operators. So it was basically a lack of foresight, which led to this financial burden, including interest penalty and loss of business flexibility. So finally, what I'd like to conclude here, because otherwise the video will become very, very long, that the agencies which adjudicated this particular case always maintained that operator cannot challenge the migration package. As simple as that, because they have benefited from it. It's here, it's written here, benefited from it. However, they have forgotten the fact, and they conveniently ignored this fact that DOT also benefited. Because if the migration package was not there and it was not proposed, the industry would not have flourished like this. They would not have got that kind of penetration of mobile phones and the goodwill emanating out of it. And it is also clear from this case that neither DOT nor the operator clearly understood the definition of revenue, which is also very strange, and it looks very funny also that you have an agreement, a migration package in 1999 until 2010-11, and even continuing forward, that you did not understood the definition of revenue and you kept on demanding. DOT initially gave some relaxation, which they withdrew later. So there is a moral question here. It is not a legal question. It's a policy issue for the DOT and the operators to take that into consideration. That DOT should have taken a stance from the very big, or an approach from the very beginning, which should have been more inclusive. That is, they should have explained from the very beginning that why they are taking such a stance on including non-telecom revenue with the telecom revenue. Because if they had done that, and if they had made the consultant report public in the beginning itself with the operators, then there could have been some consensus building activity which might have happened in the beginning itself. So DOT set the expectation in the initial stage itself at the migration package that they will deal with this issue in an amicable fashion with the proper consultation, but they unilaterally rejected the TRAI's recommendation without giving any reason. So it basically shows that when you are dealing with policy issues, it is actually not about what the rules are. It is the perception which matters. How you deal with the people who you are regulating, what kind of perception that those people have on the regulator over the issue about fairness. If you are not able to give a perception that you are acting fairly, you may be acting fairly, but that is not going to give you that kind of dividend that you are looking at. So I think I would like to conclude, and then we can discuss the other issues in the other part of these presentation series. Thank you for your patient listening as usual. Thank you very much.